Hi everyone, my name is Vincenzo and I'm giving some thoughts about heterodox views of corporate law. This is largely a theoretical paper and draws on an article that I recently published with a US journal, and it's really very much a work in progress, so that's why I'm still really researching on that and trying to find new avenues and complete this proposition. The paper, in fact, is largely grounded on the proposal of an alternative theoretical model of corporations. And I'll slowly illustrate how I got to that. But let me give you some background on the idea and how I thought it was important to actually research on this. Roughly a year ago, I was at an exhibition at the Natural History Museum in London. And there was a sketchboard with the map of the world highlighting different problems that affect the planet. Among these problems, I'm listing some of them. I wish I had an exhaustive list of them, but environmental issues, broadly speaking, obesity in the developed world, hunger and poverty in developing nations, pollution and related diseases caused by the extraction of natural resources, human rights violations, and finally, abuses of corporate power. As I started thinking about that, I was with my wife, I couldn't really emphasize how I thought that abuses of corporate power was what actually was underscoring all the other problems. So in my view, all the other problems were actually rooted in abuses of corporate power. Without corporate power, without the availability of the corporate form, the other problems would occur in a much slower and smaller scale, and maybe they wouldn't occur at all. And I'll draw examples of that throughout the paper. So the problem, obviously, for those of us who are not really familiar with corporate law, the problem is grounded on the possibility, from a legal perspective, to form corporations. And that entails, for the purpose of this discussion, two main consequences of incorporation. One is the separate legal personality. So once a company is incorporated, it is a separate personality, it has a separate personality from the people who incorporate it. So, largely speaking, we talk about the shareholders, who are the owners of the shares of the company, or the people who make decisions in the company, namely the board of directors or executives. And together with that, we have another legal consequence of incorporation, which is the separate legal personality, meaning that the liability that is incurred by the company is distinct and separate from the liability that may be incurred by the people owning shares in the company or taking decisions on behalf of the company. Again, without these two principles, without these legal consequences, it would be much more difficult to conduct business and allow for externalities. Externalities is an economic word meaning the damages that are created by the business of the company. It would be much more difficult for externalities to be created in such a fashion. So what is the question? The question is, to what extent do we need the company as we have it today? What are the rules that govern the behavior of companies in society, especially those companies that are large enough to create those damages that I highlighted in the example earlier, like natural disasters, pollution, influencing hunger or obesity in the world? What are these companies that are large enough to create these damages? Is the company a good citizen? Is the company behaving rightly in the jurisdiction in which it is incorporated? Is it really a matter of national law, a matter of the nation in which the company is incorporated, or is it a matter of international law? And I should emphasize the international and global breadth of this problem, given that we are here hosted by the Manchester International Law Center. And we very much believe that it is an international law problem. It's a global problem. More importantly, especially for the purpose of my inquiry, is what are the group of people that are identified or that we can identify with the company, especially with the decision-making process of the company. Because clearly these damages are the result of decisions that are taken within the company by professional managers, allegedly. And the question then arises naturally, what are the rules that govern these decision-making processes? And eventually these decision-making processes could make the company a good or a bad citizen. So at this stage of this paper, of this presentation, I'm really focusing on an old, but really not yet resolved dilemma, or an old quest, that is to address the fundamental legal issue of identifying and regulating the objective of large corporations. Objective meaning the corporate goal. So what is the purpose for the existence of these companies, and what set of rules determines the extent to which these companies actually stick to this goal and pursue this goal. This paper advances the idea that corporate decision-making, which, as I said, flows directly into corporate power or into a manifestation of corporate power, should have a more democratic underpinning and should be accountable for all those social groups, really, that are affected by corporate decision-making. So there should be essentially a social justification behind corporate power. How do we do that? So my initial questions, my initial framing of this problem is to ask a question: who bears the burden of the consequences of corporate actions? So if you are driving a car as an individual and you kill somebody as a direct effect of your driving, you will be personally liable. There will be personal consequences, not just legal consequences, but also moral and ethical consequences that will affect the person who was behind decision-making. Decision-making, for instance, of speeding excessively, of not respecting street signs, and so on. But if the same sort of accident happens within the context of corporate activities, pollution, extraction of mineral resources, who is responsible for that? Who bears the moral burden of the underlying decisions? One example to explain that is that of French car manufacturer Peugeot. It's an example that gives you the idea of how corporations are fictional identities. Peugeot used to be identified with a guy named Peugeot, I think. I don't know the first name, but his surname was Peugeot. And he started operating as a sole trader. Sole trading means that your business is identified with your own persona, with your own personality. That means that in case of default of Mr. Peugeot's debt, for instance, he would have been liable personally with his own assets, his house, his warehouse, his tools, and so on. Today, Peugeot is identified quite differently. So we could say that in the past, Peugeot was identified with somebody, with a person, with somebody who was clearly identified and identifiable in the physical reality. Today, Peugeot is identified at the most with a lion, which is the brand of the company. So, where does the board of directors of Peugeot meet? In what building? Who do you identify with them? Who owns the share of Peugeot? Who owns the shares of this company? Who owns the shares? Probably thousands of people, if not more. So this means that there's been a process and also a problem, I would suggest, of depersonification of corporate actions. Nobody can really identify who is behind corporate actions. Yes, we know that the board of directors is responsible for most decision making. But this is still a process of depersonification. The business corporation doesn't have any connection with the physical world, and this is a fact. It is in fact the result of an individual collective imagination, and here I'm going a little bit on an anthropological view of the company. It's the effect of individual collective imagination. In the case of Peugeot, is the imagination of a lion printed on a car, or on other badges representing that car. People effectively believe in a common myth, the myth of the company. We trade, we deal with companies on an everyday basis. And this is obviously the effect, every creation of myths is the effect of something. We believe in religions as myth because we believe in the underlying holy books. We believe in the company because we believe in the statutory rules that give right to the company. In fact, in the parlance of company law, we speak of legal fiction when we talk about corporate personality. Obviously, the myth of the company is stronger in certain communities. Which communities am I talking about? Well, the myth of the company goes hand in hand with the myth of accumulating value. And I'm talking specifically about material value, accumulating money, accumulate material items, material value. And this is spread at the societal level. And effectively, the business corporation is something that we have to identify as the organization that is designed to actually elicit and magnify the accumulation of value. Okay? So clearly that tells you that the myth of the company is stronger in societies where the values and the myths are aligned with this sort of capitalist construction, which is the accumulation of value. This leads to another problem, and a problem that is more inherent to the way in which corporate law has, over the past century or over, organized the regulation of corporate activity. And the question revolves around the friction between the private power that underscores the decision-making process, in other words, in whose interest corporations make certain actions. Okay. Traditionally, we think that there is a private interest behind that, which is the interest of shareholders, so the people who own shares in the company. This is opposed by a public interest in the company, which is a public interest vested really in all those social groups that have an interest in the company. And this tends to be a more democratic-based kind of interest. Because effectively, if we think about large companies, the social interest is not only the interest of other groups within the company, like for instance creditors or employees, but it's actually the interest of all those social groups who are affected by the actions of the companies. So the community in which the company is based, the environment, employers outside the company who could be affected by the effect of the default of the company, and so on. The larger the company, the wider the area of interest that are affected by corporate actions. Beyond this classical dichotomy between private and public interest, we have to take account of a new dimension of corporate power that I think has been achieved over the last 20 or 30 years, especially since the 1980s, and I'll say in a minute why. The manifestation of corporate power today have largely superseded the powers that can be exerted by national states, for instance. Think about the possible outcome of transatlantic trade agreements, for instance. Now, this per se is not new, because I always think when I read some historical text of the East India Company, and I think the board of directors of the East India Company was much more powerful than many present states. So corporate power is not new, but there was one East India Company back in the days, and probably a handful of other similar corporations. Today we seem to be surrounded by entities whose size, whose power to influence lawmaking processes is never-ending. And I think what today makes things more problematic with respect to corporate power is the problem that has been identified by some scholars as financialization. Now, financialization can be described from many perspectives. I would stick to a very basic understanding, and I'm happy to take questions on that debate. Is effectively the ever-increased interaction between the business corporation and the capital markets, or generally the financial markets, the finance logic. This accentuates the alignment of the corporate decision-making with the mere pursuit of the increase in the value of shares. Because the premise of financialization is that the company in question is listed on a stock exchange or has an interest in the financial value of its shares. This means that the success of the company will be gauged and reflected in the value of the shares, or the value that is expressed in the financial market. And this very often departs from the fundamentals of the company. Now, one example of that. You may or may not remember that in 2014, one UK pharmaceutical company called AstraZeneca was on the verge of being taken over by another pharmaceutical company from the US called Pfizer. Now, so far, nothing strange. Takeovers and mergers do happen. But the problem is, first of all, the nature of the UK company, which is the largest pharmaceutical company in this country. What does that mean? What does that tell us? It tells us that there are certain social expectations from this company. Expectations to actually drive and lead research and development in the pharmaceutical sector. Expectations to provide pharmaceutical products at available and fairly cheap prices. What would happen if the company would be taken over, first of all, by a foreign company who doesn't necessarily have interests in this country's research and development, and also by a company that has a reputation, like Pfizer did, to actually break up target companies, extract value from them, sell them off again, and destroy therefore competition and see the price of their shares increasing. So what would be the effect of that sort of transaction, of a takeover of a national interest like AstraZeneca? And that became, in fact, the core of the debate behind the attempted takeover of AstraZeneca. It became quite political. It was questioned whether there should be a public interest test behind similar takeovers. There isn't such thing in corporate law or in the law of takeovers. There isn't such thing as a public interest test. Why isn't there such interest? And answering this question, I move to a slightly more legal part of the presentation, which is the character, the feature of corporate law in the UK or in the US. Critics of corporate law always say that Anglo-American corporate law has a narrow framework. What do we mean by narrow framework? What we mean is that the legal framework around corporate law is mostly concentrated on the regulation of the relationship between shareholders and management. Because traditionally shareholders own the shares in the company, you have many shareholders, therefore decision making is delegated to a professional board, that is the board of directors. Company law, therefore, is concerned primarily with that regulation, that is the regulation of that relationship between the board and shareholders, and to create relevant mechanisms of accountability, if any. This framework, this normative framework, however, we call it narrow because effectively fails to regulate relevant relationships outside of this spectrum. Even relationship, for instance, between the company and its employees. Well, we do have employment law for that, but sometimes we think that it would be helpful if company law was to regulate the duties of the board towards employees. I argue, like other people have done, that this narrow framework is no longer sufficient. It fails to take account of the multi-layered and multifaceted dimension of corporations and of the importance of other stakeholders in the company. One prime example that has become extremely relevant in the last 10 years or so, given that we are still living the aftermath of the global financial crisis, is the example of banks. What if we accept this narrow framework in the regulation of banks? And let's remember that banks are companies. Banks are registered and incorporated as companies. Well, we would neglect the role of depositors. And let's remember that unlike a small company, the maximum risk bearing in a bank resides with its depositors, not with the shareholders, certainly. Probably we could configure taxpayers as risk bearers of a bank, because if the bank fails, in the UK, the Bank of England is bound to bail out the bank, which means that taxpayers' money will be at stake. In the US, this is not the rule, but it may happen. So taxpayers have an interest in the way in which banks are run. So the question that we are faced with is, how can different interests be accounted for in corporate decision-making processes? How can we achieve that legitimacy of decision-making processes and achieve a certain level of democratic backing of those decision-making processes? Now, the quest to find this sort of legitimacy is not new. And I'm here pointing to two prominent scholars who in the past have tried to construe this sort of legitimacy. One is the American Adolf Berg, who wrote in the 30s and up until the 60s. And Berg dismissed the power of the market to create these discipline mechanisms. So if we had any doubt, Adolf Berg dismissed them a priori. He said the market is inefficient, plus investors in the market are irrational, preempting all the behavioral finance scholarship. We thus need to resort to a community of experts to take decisions. And what he referred to is professional managers, effectively the board of directors. We ought to think of them as experts. The extent to which they are experts today is in jeopardy. We don't really think that they are up to the task of taking decisions. And Berg also interestingly said, but to my understanding he didn't elaborate further on this, he said that these experts would be accountable to a public consensus. Now, this idea of public consensus, as far as I know, was never elaborated too much further by Berg. Probably it remained a little bit abstract, and that's one thing that I am trying to go a little bit further into in this paper. So what really is the accountability, beyond the accountability that the board has towards the shareholders? More recently, in the 1980s, John Parkinson, a UK scholar, he wrote on the topic, and Parkinson viewed corporations as entities whose powers could shape society, for the good or the bad. Therefore, a public outcome of private, internally generated decisions should have been legitimized. So we need this legitimization because privately generated decisions have a public outcome, are public in the sense that they are relevant to a broader social spectrum. So effectively, Parkinson is the first to speak in certain terms about a social purpose of corporations and a level of public accountability and public interest that should be configured. Now, a little bit of a digression now. I think is needed, because so far I've made examples that are really relevant by and large to UK and US corporations. However, at the beginning of the conversation I said that this is very much a global problem. It has become global because the speed and level of globalization has become such that the operations of a UK company can have effects on another part of the world. Think about the BP oil spill in 2010. BP is a UK company and who suffer from the externalities, so the events affecting the corporate actions of BP is all the communities of the Gulf of Mexico, the environment in the Gulf of Mexico, other industries like fishing or tourism in the Gulf of Mexico. So the problems created by corporations are global, because corporations are organized, as we know, through groups of companies. They operate worldwide. However, there are different models to control corporate power. We do have, if we look historically, if we look through social legal analysis of corporate law, we do find different models to govern corporate power. And this goes back to what I said earlier about the myth of the company. Well, the myth of the company goes along other societal structures. In other culture, in other social and institutional arrangements, the company will enjoy less of a freedom to create actions that affect other constituencies, other social groups. So the myth will work in different ways. In other jurisdictions, perhaps, the company is identified with different sorts of myths. So there are different ways, in other words, in which individuals imagine collectively the company. Now I'm drawing here a few examples just to illustrate how this can materialize, but I think I'm sure there could be more to say on this particular topic. Take the example of China, for instance. In China, most large corporations are still state-owned. What does that tell you? It tells you that the purpose for which business corporations are created is to see them as vehicles for the pursuit of specific social and collective goals. So the accumulation of private value is not the reason for which business corporations are created in China, clearly. I'm not suggesting that modern China doesn't see accumulation of value as a goal, but clearly it doesn't happen through the incorporation of large public corporations. Another viable example is that of Southern European countries, being from one of them, where corporate power is really the longa manus, so it's essentially is the other side of individual or family power. So very often the corporation is closely identifiable with an individual or a family. Okay, so corporate power is very much individual power through the veil of incorporation. There's an interesting book on dealing with these sorts of issues called Bedouins of the Cyrenaica. And another more viable example for the purpose of this paper is that of Germany or generally Scandinavian countries. It's a closer example to, it's a closer form of corporation to the one we have in Anglo-American societies. Here, large corporations include employees' representatives in the board of directors. So effectively, through this co-determination system, you have a more diversified decision-making process on the board, whereby you take account not only of the interest of shareholders, but also of the interest of employees. Okay, so effectively, you create a dichotomy between these two centers of interest, these two centers of powers, shareholders as equity owners versus employees. My argument is that this is no longer sufficient because the company is not really reflected in this dichotomy. It's much broader, it's a much more varied range of interests. Traditionally in the UK and US, now, if we try to bring this discourse on a theoretical level, in the sense of how can we think about a model that governs decision-making processes and corporate powers in corporations, we have two main models traditionally that we have thought of as alternative. One is stakeholder value, one is shareholder value. Stakeholder theory is really reflected in what I said about Germany and Scandinavian countries. I won't say much because I don't want to linger too much on this theoretical debate, and it's really no longer central to the paper. But both stakeholder value and shareholder value, the latter being predominant in the UK and US most typically, both have proven to be to have shortcomings, effectively, not to respond, not to meet the necessities of modern corporations, for a different range of reasons. Some theoretical, some practical. Especially shareholder value has been linked very clearly, very closely, to all the corporate failures of the last 15 years or so. Shareholder value remains, however, the paradigm of corporate decision making. And it's no longer only relevant in the UK or US, but for a number of reasons, it has expanded. And these reasons are not just to do with the legal framework of corporate law, but also with corporate governance. And corporate governance methods, corporate governance cultures are much more easily exportable because they are not enshrined in statutes. Okay, they are enshrined in what we call soft law. Now, I argue more extensively in the paper that neither of these models can provide a valid framework to address the problem of corporate power and to direct corporate power in a more social dimension, towards a more social dimension. The problem is, the underlying problem is one of insufficient legal framework, and we have to think about both internal control systems, so what are the internal systems of control within corporate law, and what are the external systems, so outside of the company. There's a problem of flawed risk management system, so what is the system of rules and regulation that is supposed to control the risk-taking, the level of risk-taking that a company is taking. Risk-taking, do not only think about financial risk-taking, a bank defaulting or failing. Think also of the risks undertaken by BP when they were conducting the extraction of oil in the Gulf of Mexico. So what was the system of checks and balances? What was the risk management system in place that allowed BP to actually keep drilling despite the risk of creating that type of ecological disaster? So there are very many dimensions of risk. What is the role of shareholders in the company? This is another key and topical debate. We keep thinking that shareholders are the ultimate controllers in the company. And what I would suggest, especially to my students, but not only, this is another mythical figure. Today, shareholders are not those who found and started the company, like Mr. Peugeot. Not at all. Shareholders are people who buy shares in a company as a means of investing money and achieving a return. So they buy shares in the company when they think the price is fairly cheap, and they sell again when the price goes up, thereby making a return. So thinking that shareholders will play a part in controlling the actions of the company is simply delusional. In most modern company law systems, we have, since the 1980s, we have another mechanism of control which is called non-executive directors. This should be those who control the board of directors. It's been ineffective for a number of reasons, and we can talk more about that later with questions. So effectively what I think is that we need a completely new legal and institutional framework within which at least large corporations should be bound to operate. Okay, this is obviously highly controversial. It's bound to be controversial because most large corporations would not be able to operate under a more restrictive legal framework. They would not be able to operate and to make the profits they do under a more social framework of corporate law. Now, my proposition is, I called it Enlightened Sovereign Control. Now, before going on about justifying, I'll explain why I called it Enlightened Sovereign Control. So the three words, essentially what I argue is that we need to rebalance the dichotomy between economic and social interests for which corporations exist. So we need to balance these concerns through an enlightened approach to the regulation of the company, and enlightened, essentially I mean balanced approach. And I argue that this approach and this control of corporate power has to be conducted by democratic-based institutions, and that's why I use the word sovereign, because that entails the use of a state institution. And control essentially is the control of corporate power for the benefit of broader social concerns. Now I'll get back into what I mean by state intervention, because I don't actually mean direct state intervention, but there is an institutional construction behind that. So the theoretical justification for my proposition is grounded on some of the writings of a number of scholars, and in the paper I delve a bit more into what they say that is relevant. I'll just mention them. Larry Mitchell, who goes by a different name these days, Janet Dine, Gunther Teubner, Eric Horst. Overall, they all point, in a way or the other, to a greater recognition of the social priorities vis-à-vis the economic ones. So the social and welfare interest should be embedded among the corporate objectives of large corporations, simply because these corporations impact on a wider range of social groups. As I said earlier, there's a strong institutional dimension to this proposition. Effectively, my proposal has more to do with public law and institutional economics than with company law. Once we move into discussing the proposition, there's little about company law. There's more to do with institutional economics and public law. And I very much agree with some scholars when they say that company law, to a certain extent, should no longer be seen as an area of private law, but we really should be thinking about that as public law. Okay? So my institutional dimension is designed essentially to provide that legitimization and that democratic backing, so to bridge the democratic deficit essentially, under which currently corporations operate, large corporations at least. My institutional dimension is based on a two-tier classification of corporations. I'll explain on what ground I classify companies in a second. And the entities that, following this classification, are recognized as having an impact on a wider social group should have their decision-making process legitimized through a democratic process. The state, I argue, is the natural custodian of different and pluralistic societal interests and values. In the world we live in, we have nothing but the state to represent the pluralistic interest of society as a whole. We haven't got a social design that allows us to look elsewhere at the moment, as far as I'm aware. And my institutional design is also premised on a permanent institutional body. Now, we don't have anything like that now. So if you were to think about an easy fix to corporate power, well, this isn't the solution, this isn't the recipe. Because even if you wanted to implement this sort of institutional construction, it would take a few years to get it going. And there are examples of institutional bodies that operate along the lines of the one that I am proposing. So I'm thinking about a permanent institutional body that should be independent both from government and from the market. Now, most institutional economic discourse about independence is concentrated, is focused on independence from government for obvious political and ideological reasons. I think the time is right for us to think a bit more broadly and openly, and an institutional or regulatory body needs to be independent from government but equally from the market. And we have plenty of examples these days of regulators who are affected by the problem of revolving doors. The head of the European Central Bank is a former Goldman Sachs banker. The head of the Bank of England is a former Goldman Sachs banker. Are we all fine with that? Are we all okay with that? I don't think we should. So that's what I mean by independence, both from the government and from the market. Under the two-tier classification, essentially, professionals working in the institutional body, so this sort of regulator that I'm proposing, would be drawn to operate in the board of directors of tier 1 companies. They would still be remunerated with public money, with the institutional body's salary. They wouldn't be remunerated by the company that they operate within. The idea of these people working for these companies, of these professionals, is to implement a predetermined corporate objective for all these tier 1 companies. And a corporate objective that is aligned, in fact, with the multidimensional character of the business and the varied type of stakeholders involved in this type of business corporations. Now, what makes a company a tier 1 or a tier 2 company? So where do we draw the line? I've come up with 5 criteria which should help us discern which companies deserve this form of sovereign control. So the first criterion is the entity's size and number of employees at group level. So we get rid of separate legal personality for the purpose of this classification. We need to look at group level to be fully aware of how really large is the corporate power. What is the impact of corporate power? And we can only ascertain that if we look at the group level. So size and number of employees. Why is that important? Well, because if there are many employees involved, then workforce, employment become key issues. Similar to that, group's turnover. This is relevant because it tells you something about the fiscal and financial repercussions that these companies have. How much taxes do they pay? Do they pay the right amount of taxes? Do they contribute to the societies from which they extract value? And another key issue is relevant here, that of the audit. If you think about audit and control, that is a huge problem with respect to large corporations. The audit was one of the main drive behind the North American scandals of 2002 and 2003, like Enron, WorldCom, and so on. Well, it has only been partly addressed. Third criterion, the geographical spread of large corporations, large business corporations. Well, that tells you something about multidimensional firms. There are here issues of competition, issues of economy of scale, the ability of corporations to extract value from society by destroying competition. Well, by looking at this criterion, you'd be able to socialize and internalize some of the economic advantages that corporations are able to take by spreading worldwide through groups of companies. Similar to this is the fourth criterion, which is the range and nature of business. And here we have the problem with conglomerates, a problem that has become very clear with banks. Who hasn't heard about the tag too big to fail? Well, too big to fail is not just a question of size, it's a question of banks doing too many things and becoming indispensable for society, for consumers. This doesn't just happen for banks. What about the University of Manchester being a property developer speculator? Are we all okay with that? Does it comply with the social dimension that an academic institution should have? Probably not. So here we should really look at the public interest test to justify the range of activities that the business corporation engages with. And the fifth criterion is just a measure of all this. It's the measure, really the amount of externalities that are imposed on social groups by virtue of the previous four criteria. So, just for the company law funds, for the fund of company law, how would this construction affect corporate decision making? Well, you would have a minimum number of professionals sitting on the board of directors of these corporations. I would say a number of 3 would be sufficient. Obviously, this creates, some people would argue, a huge bureaucratic apparatus. But corporations are huge bureaucratic apparatus as well. So it's nothing new. We live with that. The costs, yes, taxpayers would have to pay for that. But is that more expensive, do you think, than the costs imposed by corporate externalities? Think about the millions that we would be able to reap in tax revenues that currently are waived. Okay. Think about the effect of corporate defaults on employment, on financial stability. So the passing of major resolutions at board of directors level would have to pass the agreement of the majority of the professionals sitting on the board. The professionals sitting on the board would have a power of veto over high-risk activities. Alternatively, they could refer certain decisions or certain policies back to the institutional body, which, I repeat, is a permanent sort of regulator. So this would facilitate effectively an ex-ante gatekeeping function, something that we could associate with what non-executive directors are supposed to do but have never been able to do really. And also, I would argue that the creation of these professions should be seen really as a new profession, bringing about new intellectual and new social values into the business world. And when I thought about the construction of this institutional body, I don't know if anyone is familiar with the literature, but I really looked at Gian Domenico Maione and that stream of literature on institutional economics. I'll stop here, and I'm happy to take questions on any aspects of the presentation. Thank you.
So just to kick this up, Vincenzo, thank you.
Pleasure.
Very provocative talk. And to the private commercial law hub cohorts that are all around here at every level, and the MILC cohorts, this is just a real pleasure to get to spend time together. We've got about 20 minutes for Q&A, and then we'll pop over to Crow for anyone who wants to join us. Does that sound like a plan?
Cool, yeah.
All right, all yours.
Thank you very much. It's the second time I'm hearing the presentation of the paper, and I'm glad to see that even though for my taste it hasn't crossed the boundaries of orthodoxy, so it's not heterodox yet, it's getting there. Nonetheless, it is radical. But let me explain why I think it's not heterodox yet. I'll be very brief. Primary problem, if one wants to be heterodox, is that the paper still retains the basic structure of orthodoxy, which is that we still need the bureaucratic corporation in our society. You did mention China as an example of a different use of this bureaucracy. To me, the Chinese use of the bureaucracy, of the corporate bureaucracy, is not that different from our own in the communist society or non-state controlled, state-planned societies. I think it's pretty similar. They're about wealth accumulation, accumulation, not even creation necessarily. They're about power accumulation. They're about controlling the markets, something that Adam Smith himself was really critical of in respect of corporations. He hated corporations, believe it or not, because he thought they were anti-competitive creations. So I wouldn't treat the Chinese model very differently to the non-Chinese model. But my main objection is that, I was supposed to be brief, yeah? My main objection is that once you decide that this creature has to stay in our society, as it is, I don't think it's possible to control it. Because by its nature, it's supposed to defy control or internalize control. So if you impose a different objective to it, like the public interest, I cannot see how this is going to be feasible, because first of all, who is going to determine what this objective is? How are you going to define public interest? Is it the growth of GDP, economic growth in the UK, for example? Well, how is this any different from what we're doing now? Is it going to be the protection of the environment? Okay, so BP, what are you going to do with BP? Are you going to tell BP that, okay, now you need to shut down basically because you are anti-environmental? So you cannot reconcile these issues. So if you retain this structure, you retain the problems. And I don't think, so that's an old debate going back to Max Weber and how wrong he was, but I don't think you can combine bureaucracy with democracy. There is a long literature, that's the heterodox literature, that you can start incorporating now.
I disagree with that stream of literature. Okay, I'll take I think these are very good points. I think you are right when you mention China. I think the problem is that even if we go back to Middle Ages, we've always had, and we will always need, as long as we are not organized in tribal societies, forms of organizations, which today we call the company, but we could call it differently, that are used to channel resources and then in turn are used to achieve certain collective goals. I mean, incorporation started in Middle Age in a very primeval form for churches, for evangelical institutions. I think, yeah, in China it is definitely, I think, a bureaucratic apparatus. But the key difference is that the bureaucratic apparatus is used to achieve completely different goals, which are aligned with collective goals, with social goals. So the achievement of the wealth accumulation in China, I would think, occurs via different channels, which will be regulated outside of corporate law, of course. So it's no longer a corporate law model. So I think we need an organizational form that we can call company or something else. We think we need an organizational form that channels resources, especially when it comes to entrepreneurship. Okay, I think we need it, because otherwise those resources may be channeled somewhere else, and what I mean is that there may be other channels of power, and that may be undesirable as well. I see your point on power side, and I think that is interesting. I think what we see today, what we have seen for the last 15, 20 years, is, to a certain extent, an homogenization of corporate law, whereby corporate power has become commonplace, even in jurisdictions where corporate powers was much less of an issue. And this is because the Anglo-American influence has meant a facilitation of corporate law in jurisdictions where the normative framework of corporate law was not facilitated, was not permissive. I think some Southern European jurisdictions are a good example in that. If you look at the number of large corporations in rankings like Forbes, for instance, you will see that the number of large corporations in countries like Italy or Spain is very, very small. So the accumulation of private power within large corporations is very common in Anglo-American jurisdictions, so US and UK primarily, much less so in Italy, France, Spain, and so on. What that means is that the corporate structures per se does not mean corporate power. The fact that you have company law, the fact that you provide the possibility of setting up a company does not automatically mean that there will be a problem with corporate power. I think this is the result of the direction of the policy and legal direction of the last 25, 30 years. But it's not a necessary status. And I think what was different in some continental European jurisdictions is that there were more obstacles to corporate power. So I agree with you that it will tend to that direction. And I also said that corporate power in the Southern European economies, for instance, was identified with personal power. The collapse of Parmalat is an example in that sense. So it was an individual identified with the company. When you think about my most famous compatriot, Mr. Berlusconi, you do not think about all these companies. You think of him individually. These companies are the means through which he exercises power. We don't call it corporate power, but actually that's what it is. Okay. However, there used to be obstacles, and there used to be mechanisms that constrain and mitigate corporate power and the externalities that come from corporate power. And that's where I disagree with you, because I think with the right institutional and legal tools, corporate power can be restrained. But the problem is that today we are defeatist because we come from 25, 30 years of orthodoxy that says that regulating company law in particular is inefficient. It leads to costs. It leads to inefficiency. It leads to losses of growth, losses of entrepreneurship, losses of innovation, missed opportunities here and there. And I think beyond the scope of this conversation, but I mean, we have had many chats about that and we'll have more. I disagree on the alignment between democracy and bureaucracy, yes. But that's a different talk, yes.
Can I know how many car manufacturers are there in Italy now?
Now, operating in Italy.
Well,
manufacturing in Italy.
Yeah.
I mean, if you talk of brands, I don't know, quite a lot. With plants in Italy,
yeah.
I think very, very few. I don't think Fiat should have been allowed to move to Amsterdam. Again, the discourse of ownership. Who owns Fiat? Yes, there's a family that founded Fiat. How many shares do this family own in Fiat these days? 1%, 2%? So why would you allow a company to merge with a foreign company, I think it's a US one, and to move to Amsterdam for whatever operational, fiscal, tax planning issue? You nationalize the company, you keep it there, otherwise you ban it from the local market. And I can guarantee you that Italians are the largest slice of consumers who buy Fiat cars. So it's a simple, you can't extract value and take all the positives while ditching all the costs. I think it's a fairly simple societal arrangement. But yes, you are right, and it's not just the car manufacturing in Italy. There are other huge chunks of manufacturing that have disappeared, like the clothing. Nothing is produced in Italy anymore. It's designed in Italy the most, and it's produced. somewhere else.
Okay, I'm not actually sure what you presented, Vincenzo, or how your presentation went. But thank you. I'm sorry for coming a bit late. Yeah. Now let me play the devil advocate here. Somehow, maybe many people would see with me. What is wrong with corporate power when there is corporate social responsibility? And what is wrong with having conglomerates, large corporations, where they employ citizens and give jobs, solve the problem of unemployment? What is the problem with that?
That's a good point, actually, because I haven't talked about CSR, so corporate social responsibility. Effectively, corporate social responsibility is a brand.
A brand.
It's a tag, and the problem is that from a legal perspective, corporate social responsibility doesn't bite, in the sense that it remains a soft law mechanism. Corporate social responsibility does not translate in specific legal obligations that companies have. The only country that actually embeds CSR in its company law statute is Mauritius. And having been there on an annual basis, I can tell you that even there, with CSR embedded in company law, what you have is Ernst & Young and all the big companies or manufacturing firms or whatever building nice gardens outside their office. That's CSR, that's corporate social responsibility. And you do have large manufacturers who create externalities in Mauritius. So your second part of the question was, what's wrong with corporate power? And the short question for that is externalities. And the larger the company, the more difficult it is to control the externality. To control, to measure, to quantify. Externality means essentially the damages that are created by the company by virtue of its actions and that are suffered by a large slice of social groups. So for instance, in Mauritius you have a tuna can manufacturer that operates absolutely in the shadow, without safety and whatever. So I wonder, what does CSR do for that? Yeah.
But I guess the reason they're operating like that is not because there is no CSR there. Maybe perhaps it's because they are just taking advantage of somehow the weaknesses in the implementation of the legal system. Because if you have a legal system that is well enforced, I think that won't happen. By the way, can you name a company, a multinational that you think is a good company from your own perspective?
Oh my God.
Or are you just against all kind of multinationals?
Multinational corporation, I think is good. I don't know. I'll have to think about that. But when I go and buy food, I'll give you this example. When I go, okay, the first part of your question. In Mauritius, being a part of company law, you could argue, yeah, it may be a problem of enforcement. Outside of Mauritius, CSR is not part of company law. You cannot enforce it. It's up to the company to say we do CSR or to say we don't, and to how they do them, how they do CSR, how they implement CSR, it's up to them. Apparently, BP, before the oil spill, was a big CSR complier. Just to give a dimension, CSR, unfortunately, in the world we live in, means little or nothing. So BP, before the ecological disaster that they created, was a big CSR flagship. A company that I respect, I'll have to think about that. I don't know, because Longines.
Media sense.
What's that?
Berlusconi.
No, Berlusconi is dead. He's a phantom. He's a puppet with the mask of Berlusconi. I like watches. I'd say Longines. I don't know. I'm just saying. I don't buy foods in supermarkets. I go to Charlton and I buy food in local grocery shops. But I am there. Not when you are, but I am there.
It's all a lie.
Yes. We have room for like 2-3 more questions.
Can I come to the practical proposal? The idea of professionalised directorships. You touched upon the problems we've got with revolving doors and accountability in audit. Do you have any steps to put in place to stop that happening in terms of professional directorships? Because as you professionalise that potential new career, you've got to get networks involved naturally, as humans do, and that sort of system will just be replicated in the directorships themselves. And a second part to that, if something goes wrong within the company, how do you envisage liability for the 3 professional independent directors? Are they part of the company? Are they separate? Have they got fiduciary duties? Is it some sort of different aspect of liability for their actions?
That's
because the nature of the action and the mission might be different.
Yeah, very good points. There is more on that in the paper, and there is more of that I plan to think about. So first of all, the setting up of this professional body and the people who will be then drawn to the board of directors is premised on a specific career path. So that's how I think of breaking down the problem with independence from the market and independence from government. So either you have a person nominated from the politicians, you have a problem there. If you have somebody nominated from an investment bank, you have a problem there. If you have a specific career path and somebody getting into that institutional body by virtue of a specific academy or a state exam, as happened in other jurisdictions, then you effectively break down that independency problem. But as I said earlier, this is obviously not a ready-made design, because you would have to set up the body, set up the career path, the type of education that is needed, and obviously you sort of prioritize the sort of skills that you want these people to have. Again, as I said, they wouldn't be, it's not a way of professionalizing directors, because they would work on the board of directors, but they wouldn't act as directors.
Sure, okay.
So effectively, they would be under a set of duties, but under the professional body, not under the company's duties of directors that we have for the people who sit on the board. And there would be obviously specific administrative process to hold these people liable. The third leg of your question was...
it's just what were the nature of the duties and how would you hold them liable? Would they be part of the company? If something went wrong at BP, and whilst they were on the board and they failed to do something about it, when they could have done, what's the nature of their duties? Is it fiduciary? Is it trust? Is it, as dear of directors, is it something different? And you said it's some sort of new administrative...
They would owe their duties not to the company. They would owe their duties to the professional body and as an extension to society, essentially. And that's the difference, I think. So beyond the currently in company law, we have this problem with fiduciary duties and duties of care. And they have never been very effective in addressing, especially problems of competence, And the problems of competence is what I said earlier, the risk management. How do you gauge the risk management? There's always the conflict between the objective and subjective level of that. But the way I think about this institutional design is that these people work in the company, but for the interest of the professional body and as an extension for the interest of society.
So quickly add on to that, you need time limit, you need some check.
Yes, rotations, and also the way in which they are appointed to serve on each specific board.
So I was wondering, there seems to be something conceptual in the state and the company are separate, and that you seem to be claiming that there's just not law there, or the law is weak. But is there not a question to be asked that the law is actually working exactly the way it was intended? The governments have designed it this way. The idea of entrepreneurship and neoliberalism is something that has allowed this kind of power to accumulate. So I wonder how you see this opposition between the state and the company, and then from there, how the international would be different. Because I think you can also see a number of problems where, taking up Martin's question, what happens if a company can sue another government's board because their shareholders lose value. You suddenly create sort of jurisdictional bubbles between certain companies. I mean, tax haven literature was something that started to come into my mind. Tax havens are not legal black holes or gaps. They're highly regulated, highly legalized. The externalities are created deliberately in a number of cases. So how do you see these kind of relationships between company, state and international?
Absolutely. I mean, I agree with you that company law is the way it is because it was engineered to be a facilitative, competitive legal framework, especially in the UK. As I said, it wasn't the case in other jurisdictions, but I think especially the power of entities such as IMF, World Bank, this has led to the homogenization of corporate governance and also to a set of reforms in other countries, traditionally less liberal with respect to company law. You are right, effectively. So yes, in the UK and the US, corporate power is the outcome of a specifically designed legal framework. And if you look at judges, the way in which they decide certain controversies, they don't want to take the burden of second-guessing what the board of directors deem desirable. Okay. So beyond the legal framework, there's also the judiciary. Coordinating an action plan at the international level would be extremely difficult because you have different political agendas. It suffices to say that even coordinating company law reforms at the European level was always a disaster. It never really happened. It happened for very small niche areas of company law. So that gives you a dimension of how difficult it would be. And also, you mentioned the state. Also, identifying what the state should be in the 21st century, I think it's a huge exercise of intellectual it's a huge intellectual exercise. I think people will think differently. People still believe that the state should be as light and agile as possible. I think as long as we pretend to live in a democratic society, the state is the ultimate responsible forum for the democratic interest. And so I think that's that's the framework that we should have in mind. Whether it's easy to implement, I don't think so. I think you would need probably another crisis to start thinking a bit more along these lines. And I think another crisis is not far away anyway. But the way in which reforms have been delayed or whitewashed after the last crisis is unbelievable. I would have never thought in those lines. But on the other hand, just to after 1929, you had the Securities and Exchange Commission in the US, which was a revolutionary act in those days, the first financial regulation in history, and a clear sign of state intrusion in financial markets.
And?
Again, the age of the regulation, but for 50 years, you had financial peace in the US. After the 1930s, after the New Deal. So,
no, they were accumulating for money. That's why there was no. This was an artificial peace because they were still making money because the economy was booming. I think the minute a crack started appearing in the 80s with the Japanese invasion of the markets in America, then they started having issues. So as long as you're making money,
there was much less money.
Yeah.
Investment banks were very small institutions.
but the economy was ticking. That's the important thing. The minute you start to crack it.
The point is that by enabling corporate power, you allow money making to a large greater extent. Investment banks were constrained to partnerships up until the 1980s. Look at where investment banks are now. That's a clear example of corporate power, which didn't exist before, because until the 1980s, I think 86 in the UK, investment banks had to be run as partnerships.
But I think it's the point about the state allowing the situation because it's beneficial for them. It's very, very important because this is what happened in the city in London. They realized that by doing what they're doing, they're basically creating cash cow for tax. So basically the state designed that. It's not something that happened by
of course
chance. It's a design I'm saying that's why the state and the law
Yeah.
are connected.
But if you're advocating for the partnership, you're automatically contradicting yourself on the bureaucracy point.
Well, what I'm saying is that the partnership is a bureaucracy. It's a bureaucracy that is restricted in size because obviously to reach decisions you need all partners to agree. And clearly, how many partners can you have in a partnerships where you have to reach decisions? That's why partnerships were small.
Yeah.
Um,
Liability. It's liability. It's an issue of liability with partnerships.
Yeah.
The liability is there, and therefore
The-
liability.
Mr. Blankfein has got
Yeah.
his collection of cars and pictures at stake if something goes
Yeah.
wrong.
So it's the liability issue. That's why it is bureaucracy, but partnerships are much more. Sorry, I'll stop.
So the conversation will continue.
Yeah.
Last word to Vincenzo.
Yeah, no, thank you all. It was incredibly interesting. Thank you for the question.